Strap in. Today's hearing centers on Devon Atkins, already on probation for a third-degree felony, injury to an elderly person. What follows is a rapid-fire collision of missed reports, missed treatment, no contact violations, and a courtroom patience meter hitting red. You'll hear the probation officer outline conditions every defendant is told. Report when directed, keep your address current, complete service, follow mental health treatment, and avoid the victim. The twist? The alleged victim is her grandmother, and the state says Devon kept contacting her. As the judge checks each violation, ask yourself, is this a system failure around mental health, or a defendant refusing help and court orders? Let's see where the scales land.
All right, ma'am, are you Devon Atkins? And Miss Atkins is on probation for the third-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, what would like.
Yep, I think I would.
Young man called, Ms. Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as an adult probation officer, is it your responsibility to supervise an individual on this probation by the name of Devon Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her identifier?
Right here in the blue jersey.
Your amended record. Ms. Cole has identified your probationer, Devon Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them, what they are supposed to do to follow the court orders?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do.
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Milton Center.
Okay, and describe for the court what a TTM is.
A treatment team.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact the majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself in the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24?
We just heard the core compliance violations.
Was that
The officer
involved?
testifies Devon failed to report on multiple dates, including Nov 4 and Nov 19, 2024, didn't keep her address current, and didn't document community service as required. Legally, probation is a contract. In exchange for staying out of prison, the defendant accepts strict, non-negotiable conditions. Even if community service hours were done, failure to report them is still a violation because supervision depends on verification, not assumptions. Notice how the prosecutor locks in the basics. Devon was advised at intake and again at a treatment team meeting. Question for you. If you were supervising this case, would you view these misses as paperwork sloppiness? Or red flags that the court's orders aren't being taken seriously?
Was that in violation of her probation order?
Yes.
Did you address that with her and inform her it is important to report if you have something coming up and you can let me know?
Yes.
And did she do that?
No.
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading this. No wonder everyone's.
I was about to say, I know, I was about to.
Community service. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as to her address and so that you know where she is at all times?
Yes.
And if she does not do that, is it impossible for you to locate her?
That is correct.
Did she, in fact, immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your WPS.
The main thing is her mental.
Now the temperature rises. The officer says appointments were made for Devon at Spindletop, the local MHMR provider, but she didn't attend, remained unmedicated, and crucially maintained contact with the victim, identified as her grandmother despite a no-contact condition. Courts take this seriously. Victim safety and boundary enforcement are non-negotiable. Defense might later argue services weren't well tailored, but the record here shows offers of help were lined up and not used. Another layer, when mental health isn't stabilized, it can derail every other condition: reporting, service, and communication. Engagement check. Do you think the court should pause violations to prioritize treatment? Or do repeated no-shows prove treatment won't work under community supervision?
Can I address anything?
In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been unmedicated this entire time?
Yes, sir.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Miss Evelyn Thibodeau, I believe that is her grandmother, correct?
Yeah, respectfully.
hold on, ma'am.
At some point in time in November of 2024, was Miss Atkins violating the condition the court had imposed that she not to have contact with Miss Thibodeau or Miss Thibodeau's safety?
Yes.
Any questions about that? About
No.
the count? That's count 8 with the contact. Okay.
That was decisive.
Then
The judge just found counts 1, 2, 3, 6, 7, and 8 true, on top of earlier pleas of true to counts 4 and 5. Translation: the state met its burden on the remaining allegations by a preponderance of the evidence, the probation standard, which is lower than beyond a reasonable doubt. In revocation or adjudication hearings, the court asks, more likely than not, were conditions violated? Here, the combination of missed reporting, address failures, non-compliance with treatment, and no-contact violations adds up. This isn't one slip. It's a pattern. Viewer question: if you were Devon's counsel, what single piece of proof or plan would you present right now to salvage community supervision?
again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am.
Any additions or corrections to that report?
No, from the bench.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself.
Okay. All right.
Defense pivots smartly. Put Devon on a mental health caseload, strengthen ties to MHMR, and address stability first. It's a credible strategy, if accepted early. But watch the judge. She catalogs prior services already offered: special needs, SAFPF, aftercare, and multiple appointments set by probation. The court's point: opportunity was there, but follow-through wasn't. When Devon responds that "I'm not a psycho," it underscores a stigma and misunderstanding about evaluation. These are diagnostic and supportive, not accusations. Judges look for insight and accountability. I missed X, here's how I will fix it. Instead, they're hearing resistance, while safety concerns remain. Would a structured inpatient mental health placement have changed your view at this stage, or has the window closed?
Better in this situation, and can be able to complete this
I
assessment.
mean, it's hard when
Hold on.
MHMR is not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. Did she go to regular SafeP or special? Hold on.
Special needs.
So she's already been to special needs SafeP. So that was a whole 6 months plus aftercare of drug and mental health help. So, Miss Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Miss Cole set for you, at least one. How many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
At Spinal Top.
That's what I'm telling you. That's not. I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you have.
It's called past program. I'm not a psychopath.
That's not what it's called, and that's not the reason it's called that. Okay, if you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your. I'm sorry, Miss Malfino. Did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just run around circles.
Well, and in addition, I am going to find judicial.
Key legal distinction. The judge takes judicial notice that Devon was recently found competent, meaning she understands the proceedings and can assist in her defense. Competency is not the same as clinical wellness. You can be competent yet still need treatment. Why it matters. Having confirmed competency, the court frames this not as can't comply, but as choosing not to comply. Missing appointments, resisting evaluation, and continuing victim contact. Then Devon claims probation didn't give her the needed info. The judge flatly says, "I don't believe you." Credibility is the currency here, and it's running low. Audience poll. When a judge expressly rejects a defendant's explanation, what remedy, if any, could rebuild trust in the moment?
Miss Cole would never say go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things that.
I'm gonna die, so I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you the trial court certification that shows this
I
was.
would like to speak to a detective.
This was not an agreement, and so you waived your right to appeal. I need you to sign that with
I gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, man.
I can give you up to 10. You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered
I
against.
don't have a gun.
I'm not. Just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, man.
Good, then you
I'm
don't.
to the wrong person. I'm Devon Atkins. I don't have a gun.
I'm required
No,
to read that to
I don't
everyone.
know what you're talking about. I don't have a gun.
Good. Then
Final outcome. The court adjudicates guilt for injury to an elderly individual and sentences Devon to 5 years in the Texas Department of Corrections. The judge warns that interrupting could increase time, an illustration that courtroom decorum directly impacts outcomes. We also hear the standard firearm ineligibility admonishment under Texas law following a felony judgment. Routine, but important. Big takeaways. 1. Probation is a structured privilege. Miss reports, skip treatment, or contact the victim, and the court's tolerance collapses. 2. Mental health access matters, but you must show up. Evaluations unlock medication, stability, and second chances. 3. Credibility wins hearings. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
About that. Go back with the bailiff.
Thank you.